Hey everyone, this is Sarah Kaki and Jeanette Soltis from the Atlanta Divorce Law Group. And today we are going to talk about guardian ad litems and custody evaluations. This is a very frequent conversation when we're dealing with high conflict custody cases or even some of the more moderate conflict custody cases. But it's actually surprising how many people are not aware of what a guardian ad litem is.
Yeah.
Jeanette, which we consider our child custody expert in-house, why don't you tell everybody what a guardian ad litem is exactly?
So in a contested custody case, often it's very helpful to have a neutral party who investigates and makes a recommendation to the court. And there's really two common avenues that we do this. The most common is the guardian ad litem. And this is an individual who's appointed by the court who represents the best interest of the children. And they conduct an investigation and then recommend to the court what they think the court should do regarding custody. There's also a custody evaluator, and that is typically a therapist. It's a psychological custody evaluation. So that is typically a therapist who does a psychological evaluation of both parents and then also conducts an investigation and makes a recommendation. There are pros and cons to each. One of the big issues with the psychological evaluation is it tends to be very expensive. And it's typically a more affordable option to have a guardian ad litem on the case. The guardian in Georgia is almost always an attorney, and it's an attorney who has been trained and gone through a certain process to learn about how to conduct these investigations and make a recommendation. And then your own attorney, typically it's agreed upon. If you have a conversation with opposing counsel and it's understood that, okay, our clients are not on the same page, this is going to be a contested custody case, often there's an agreement to what guardian ad litem to use, and then a consent order is submitted to the judge. There are other times where for some reason the one party won't agree to a guardian, and so you have to file a motion and ask the judge to appoint a guardian. But judges very much like guardians. One of the reasons being that in a litigation situation, the judge does not have time to delve into hours and hours and hours of specifics. A guardian ad litem can go talk to the teachers, we'll talk to the parties, we'll meet the children, we'll observe the parents with the children, we'll talk to therapists. If there's been therapists involved with the family, they'll talk to the therapist. And they're just able to gather so much more information to give to the court in their recommendation to help the court make a decision regarding custody.
And judges are typically very uncomfortable ruling against the guardian ad litem's report. Is that correct?
Yeah, typically once a guardian ad litem makes a recommendation, it is common and most likely that the case will settle. Just because the realities of going into court against a guardian ad litem's recommendation is that it's very difficult. It's not impossible, and I have seen judges not go with the guardian's recommendation or take parts of the recommendation but not all of it. But it's a very expensive endeavor to go into court knowing that there's a very big risk that you might not win if the guardian's recommendation is against you.
Well, it's going to require quite a bit of attorney time fine-combing through the guardian ad litem's report.
Exactly.
To see what they missed.
Exactly.
And at times, that could very much be worth it.
Yeah.
If you know that the guardian ad litem missed a big thing.
It is possible. If you've submitted a list of people that you want the guardian to talk to and they haven't talked to everyone, or you've submitted documents and communications between the parties, or other evidence, and you've asked the guardian to review these, if they've made a recommendation without, doing some of the work that's been requested, it's possible to make the argument that they really didn't have all of the information and they're making a recommendation that's not based on understanding the full picture.
The other part of guardian ad litems that I personally love from a litigation standpoint is going full-blown into a court and trial over child custody without having a guardian ad litem's report. You never fully know where things could end up, right?
Yeah.
And where the evidence is going to lie and how the judge is going to see it.
Mm-hmm.
The Guardian Ad Litem almost lets you test your case.
Yes, exactly.
And lets you know where the holes in your case is.
Mm-hmm.
And even though Guardian Ad Litem costs money as well, I mean, they're charging you by the hour, and hopefully you're splitting that cost with the opposing party. But either way, it lets you know, gives you a good understanding of what is your return on investment on going full blown to trial.
That is very true. And what I see happen a lot is, you know, when especially modifications or divorce where the parties have been living apart for a while, a lot of times there are just, a parent will be convinced that something's happening in the other house. And they might have a reason to think these things. Maybe the kids are saying certain things, or you know, for some reason that they truly believe this. A lot of times a guardian, once they do a thorough investigation, they're able to say, you know what? I know that you believe this is happening. I know that this is what the child is saying, but when I'm over there and I've looked at this, and that's not necessarily the case.
Right.
So it really can prevent someone from spending many thousands of dollars when the facts might not actually be there to support their case.
So overall, I mean, in these child custody cases, we're a fan of a Guardian Ad Litem.
Yeah, a guardian can be very helpful, and it is typically the route to go in a contested case. Now, if a client can afford it, I do think that sometimes a psychological custody evaluation is the preferable way to go. I have found that the therapists are typically, they work quicker, and sometimes they respond quicker, and the case can move along, you know, at a quicker pace. And especially if there's concerns about a mental health issue where you really think there's something not, you know, right here, I think we really need a psychological evaluation, then often that's the better route to go. But it's very expensive, and just a lot of clients just can't afford that. So it just depends on the resources available to the litigants as to what is the best route in that situation.
And I also think it's important for anybody that is going through this that they're careful in the selection of their attorney process. Make sure you're hiring an attorney that's worked with an array of different Guardian Ad Litems and will have a good recommendation of who to hire as the Guardian Ad Litem, because at the end of the day, who is going to be the Guardian Ad Litem, the attorneys play a part in that. On agreeing on that. And you want to work with an attorney who's worked with a number of Guardian Ad Litems and knows what they can expect from different ones, so that you are in the best possible hands of who's going to do a thorough investigation.
Absolutely.
Well, thank you guys so much for watching, and please feel free to reach out to us if you have any questions.
Thank you.